Hello and good day. My name is Leo Reed. I'm with the Office of Indiana State Chemist. I'm joined today by Dr. Jim Fredericks with the National Pest Management Association. We're both delighted that you were able to log in and catch this presentation, and saddened that you weren't able to join us in person, but maybe sometime in the very near future. I'm going to be talking about a state rule update that is happening in Indiana. Um, and then we will go into a discussion about reciprocity that both Jim and I have some things we'd like to share. So with that, I will share my screen. A couple of points I'd like to bring out prior to getting into the nuts and bolts of this new rule package that the Indiana State Chemist is working on is a little bit of history. We've been in existence for well over 100 years. However, the pesticide section has only been in existence since the inception of FIFRA. Interestingly, 33 years ago, we hired our first investigator that was also a former law enforcement officer. That was George Saxton, and Dr. Saxton is now our compliance officer as well. George was looking for a change in career from law enforcement. He also owned his own pest control company at the time. And when the position became open for a pesticide investigator with the state chemist's office, he was the first former law enforcement officer. I was actually the third. So with that, here's a slide of all of our investigators and their territories. We're going to play a little game I like to call Cop or Not. So in the bottom left, you'll see Bill Reed, who works the entire state, primarily structural. Got a nice smile on his face, surely not a cop. Nathan Davis, Southwest Territory, right above Bill there. Big smile on his face. You can pretty much tell he's a cop. Mitch Trimble, who works West Central, looks pretty serious. Definitely a cop. Melissa Roche, who works in the Northwest Territory of the state. Cop. What do you know? And there's the friendly, grandfatherly looking Kevin Gibson, North Central Territory. Cop. Andy Roth. Not a cop. Jay Kelly, who looks incredibly serious and angry, Mid-Central Territory. Not a cop. And actually, Jay does have a law enforcement background, but he was not a sworn law enforcement officer. Aaron Kreider, work in the Mid-Central Territory. Not a cop, but he does come to us from the green industry with a very strong background. Adam Brockman, Southeast Territory. Big dude, cop. Garrett Creason, who you would think was definitely not going to be a cop due to the very fine haircut, a cop. And lastly, probably the meanest of the bunch, Beth Carter. She works the entire state, not a cop. And now you know who we are and what our backgrounds are. So we're jump into the rulemaking process that we've been engaged in over the past year or so. And this rule was prompted by revisions to the federal certification and training rule, which was enacted and put into place on March 6, 2017. The state chemist office and the Indiana Pesticide Review Board, the folks that write the rules that we enforce, began discussion of the rulemaking progress back in 2019. States had to submit a new revised state plan with US EPA in order to maintain primacy in certification. And that had to be done by no later than March of 2020. All the states got those done. And then we waited for over 2 years before we received comments back. In the case of Indiana, we received quite a number of comments that we resubmitted, and just recently, earlier in the month, we received comments back on our second draft of our state plan proposal. And it should be noted that these plans are they're in depth. They're literally hundreds of pages in length. I'm hopeful that the latest plan that we submitted to EPA will get signed and approved. So we started formal state rulemaking in order to come into compliance in November of 2021. We sent our first draft rule package to the Office of Management and Budget here in Indiana in February of 2022. And then we finally gotten through that process, and we delivered our rule package to the Attorney General's office November 10th of 2022. And they've got 45 days in which to review it, at which time it can go to the governor for signature. Initially, our proposal was that we were going to impact a number of rules: the applicator certification and training, supervision and record keeping, our pesticide storage and handling, and our pesticide use rules. We wanted to get things consolidated. We recognized that there were a number of definitions that were already in law that didn't necessarily match up exactly with what we had in rule. We wanted to consolidate all those definitions, consolidate everything that a commercial applicator does into one rule, and consolidate all of our training requirements and supervision requirements into one rule. We currently have supervision requirements that exist in 5 different rules. So it's important to us that we get all of those consolidated in some fashion or another. And we also added unmanned aerial vehicle to our Category 11 aerial application category. Unfortunately, not all that worked. Anything that the Office of Management and Budget viewed as a new requirement was not allowed. So we were unable to combine what our initial rule package indicated that we wanted to combine our community-wide mosquito abatement category, Category 8, with our residential mosquitoes control, and that wasn't going to be allowed. Anything that appeared to be an additional requirement was not allowed by the Office of Management and Budget. We'll chat more about that here in a minute. A couple of things that we did in order to comply with the new federal rules, we deleted the allowance of supervision for non-certified applicators for RUP. So what that means to you is that you have to be fully certified in order to apply a restricted use pesticide. That allowed us to loosen, if you will, our general use pesticide applications, particularly for commercial use. We expanded the ways to become qualified for a registered technician. Right now, as it stands, you have to take and pass the core exam in order to be a registered technician. Because we're not going to allow the use of general use pesticides by a registered technician, we've added a training option. So you can take a half day of training that's provided by Purdue Pesticide Programs and become a registered technician. You can also take a full day of training for the core exam and become a registered technician. And lastly, if your employer or you as a business owner believes that core exam is important for your people to apply general use pesticides, you can still require that, and it still qualifies to become a registered technician. We also eliminated the requirement that no more than 10 registered technicians can be supervised by any certified applicator. We eliminated the requirement for what was called this industry-specific site assessment fact sheets. That requirement is gone, as is the requirement to have written site-specific instructions for each site. So again, some notable changes in supervision. There is no supervision for the use of restricted use pesticides. you have to be fully certified under this rule package. There's no limit for the number of registered technicians that can be supervised. And again, there's 3 different ways to become a registered technician: pass the core exam, attend the day-long core exam preparation, or attend the half-day registered technician training. It's important to remember that the rule package also indicates that all applicators must have access to pesticide labels at all times the pesticides being used. It can be electronic. The standard we're going to hold you to is you have to be able to produce that label when required. It's also important to remember that we did not eliminate the non-credentialed individuals can still make commercial pesticide applications, so long as their fully certified supervisor is able to be continuously physically present at the work site. And when we say physically present, we want that fully certified supervisor and the non-credentialed individual to be able to see each other and to be able to talk to each other. Because of that new federal certification rule, we did have to add a number of restricted use record keeping requirements, and those are on the screen right now. Take note of those. Those are also going to be on our website, but those record keeping requirements have expanded from the previous record keeping requirements under both state and federal law. So that kind of takes us into a different portion of the presentation where I'd like to chat for just a minute about residential mosquito adulticiding. This, as most of you know, in the business, it is something that's really taken off over the past few years. The idea of residential mosquito adulticiding. And I believe I read where up to 70% of our commercial pest control operators are offering this service. In Indiana, this requires certification and licensing in our category 7A or our category 8. It is not something that's allowed under our categories for turf and ornamental, as some states have it. Lots of these applications are on a schedule during daylight hours, not necessarily when mosquitoes are most active. We've gotten a number of complaints from individuals from neighboring properties that are concerned about their pollinators or their organic gardens, things of that nature. It's a benefit to the individual property owner, unlike community-wide mosquito abatement that is targeted for an entire community. Right now in Indiana, we don't have any guidance regarding pre-notification. Nothing's been crafted by the review board or by this office, and because we're under a regulatory moratorium, nothing would be done via rule anyway. So these products are applied typically by a fairly high velocity sprayer. Many of these labels indicate that you shouldn't exceed 50 psi at the nozzle tip. However, some of these misters, some of these backpack gas sprayers advertise that they have a 200 mile per hour delivery. Again, the biggest concern is pollinator protection and protection of people and pets, particularly those individuals that don't want the product to be drifted onto their property. The state regulators ask the agency, ask US EPA for some guidance. Have these products been evaluated for the use that they're being used for? Have adequate risk assessments and drift evaluations been done? And if they haven't, then what do you plan on doing? And as regulators, we did get a response back. The response was on a non-letterhead piece of paper and was unsigned, but it did clearly come from the agency. Essentially, they said, we think we've done all the exposure evaluation that needs to be done, and that the post-application risks don't appear to be of major concern. That being said, it's still a concern for those individuals who believe they might be impacted by an off-target drift or off-target direct application. So in Indiana, we do have a very proactive committee working on educational efforts. We've pulled people from industry. We've pulled people from Purdue, as well as Purdue pesticide programs, developed some very engaging in-person training, some pretty good videos, as well as Purdue pesticide programs is developing a nice publication for guidance on the proper use of these mosquito misting devices. And our intent is, since we couldn't force people into our mosquito category, we will add this methodology into our certification training and exams for both our general pest category, which can perform residential mosquito applications, as well as our community-wide mosquito category, category 8. When we get these kinds of complaints and calls where people are concerned, what we're looking at is a label violation. It's applying to a non-labeled site. Our intent is to continue our investigations much as we've done in the past. We're going to swab common touch areas. We're not going to swab or look for violations on the property line, swabbing vegetation in the property line. We're going to swab and analyze those swabs that we get from common touch areas within the complainant's property, swing sets, picnic tables, grills, that sort of thing. And while we're talking about enforcement, I'll mention that in 2021, because the state legislation required, we revamped our enforcement. And so there's a number of things that we can do. If there's a small violative act, for example, the new restricted use pesticide record keeping rules. During an inspection, we find that a data element is missing, particularly if this rule package gets signed and within that first year or so, we're trying to get everybody up to speed. We could certainly offer compliance assistance. The next step is if we find a violative act that we need to shut something down right away, is we can issue an action order to order someone to cease all operations and applications. If an investigation is completed and we find a violation, there's a written warning, written citation, a civil penalty, which is a monetary penalty. And finally, probably some of the worst things that we could do, or the most severe things we could do, is a license, permit, or registration, certification, denial, suspension, or revocation. We do the occasional modification, but typically if somebody has committed violations severe enough and damaging enough, that will go right into a suspension or revocation. And usually that is a chronic violator, unless it's something that's just so egregious that we need to pull that person's license and certification immediately. We can refer to a county attorney for criminal prosecution. That's relatively rare. It's been done just a couple of times in my 30 years with the agency. And lastly, if our state remedy, if our civil penalties don't appear like they're getting somebody's attention, then we can refer it to US EPA for a federal violation. And their civil penalties are many times higher than what ours are. We do have mitigation for our civil penalties. If the offense falls within the $250 or $500 civil penalty range, those can be mitigated downward. They can be mitigated downward for your cooperation, 20% off automatically. You took immediate corrective action, 20% off. If there's a victim that requests compensation, and you did that, another 20%. So a total of 60% of a civil penalty between $250 and $500 can be mitigated downward. Once you hit that $1,000 mark, there is no mitigation by state law. So I appreciate your time. It's again, certainly happy that you were able to log in and join us. I know I went over a bunch of stuff really quick. And this is being recorded in November. So right now, the rule package is still a rule package. It hasn't been signed by the governor. Hopefully by the time this becomes available and it's out there, it will be a final rule package. So with that, I will ask Dr. Fredericks to talk to you all about reciprocity on a national level.
Well, thanks, Leo. It's really great to be here today. As Leo mentioned, we're recording this in November, and so as I introduce myself as Jim Fredericks, the Vice President of Technical and Regulatory Affairs for the National Pest Management Association, my role will actually be changing by the time you view this in January, because at the beginning of the year, I'll be taking on a new role with the Professional Pest Management Alliance, or PPMA. So I look forward to that. But for today, I'm here to talk a little bit about reciprocal certification, or reciprocity. And this is a really important tool that many of our members use when they're operating in multiple states at the same time. And so I'd like to talk a little bit about why it's so important, and even some wish list items with regard to what NPMA would like to see in the future. But for those of you that don't know, NPMA members operate in all 50 states. We have members operating in all 50 states, plus the District of Columbia, Puerto Rico, Virgin Islands, a number of other territories as well. And so we have folks that really have a varied experience when it comes to state or territorial rules and requirements and regulations, but we all share in common the need to abide by label instructions, and all of these localities fall under FIFRA as well. There are really only a few of our members who are operating in all 50 states. So these are the truly nationwide companies. But there are a whole lot of our members that operate regional pest control companies that service multiple states at any one time. In some cases, these operations might be set up as branch locations that only service specific counties or cities or states. But in densely populated regions, like along state borders, there can be a lot of overlap in service areas across state lines. So it's in these areas that reciprocity really is the most important. For instance, imagine you are a pest control technician working where we're located here in the Washington, D.C. metro area. This map here shows a little bit of Northwest Washington, D.C., also includes some of Maryland, as well as Virginia. So imagine you start your day up the top at the Safeway on Sangamore Road in Bethesda, and you're out there checking mouse traps that are hidden underneath the bread display. Once you're finished up there, you have to swing by the Sibley Memorial Hospital to install some new light bulbs in insect light traps, check the pest sighting log, and then you move on in your day over to Marymount University, where you're dealing with some bedbug trouble calls in the dorms. In all, these 3 stops required you to travel just 6.5 miles. And under good traffic conditions, which I will admit are very rare, may only take you, say, 23 minutes behind the wheel, which is a good day for a technician. When it comes to, when we think about scheduling stops, route density for the pest management industry obviously is really important. And so the thing is that these 3 stops took the technician from the state of Maryland into the District of Columbia, and then finally wound up in the Commonwealth of Virginia. And each of these is governed by a different set of statutes, rules, regulations regarding pesticide application, regarding pest control services, and for the purposes of this talk, the certification of commercial pesticide applicators. So when we have reciprocity of certification between states, it really does make it easier for companies to get technicians certified in the neighboring states, and eliminates the need to schedule multiple tests in multiple states. Sometimes those testing times don't always coincide, and it can be problematic. It really does streamline the process for companies and allow them to be more efficient in routing and more effective, honestly, in their pest control efforts, because they can send their best technicians to tackle specific issues like the mouse problem at the Safeway and the fly lights at the hospital and the bedbug calls at Marymount University here, instead of just sending a tech out because they're certified in that state. It also allows, honestly, for flexibility when technicians call out of work and someone needs to fill in, or you have a big job and you need multiple technicians to help out. So there are plenty of places like the DC metro area all across the country where reciprocal certification really is just an absolutely great tool to keep industry from just getting bogged down in in the minutia of scheduling and testing in multiple places. So the good news is that many states currently have reciprocal certification agreements with, in many cases, their neighboring or adjoining states. And sometimes these are official reciprocal agreements between state lead agencies, or in other cases, it could be a case-by-case basis. And we've seen that when you have a technician that's hired that moves from California to New Jersey, perhaps the Department of Environmental Protection in New Jersey might consider a reciprocal certification based on that California certification. Those case-by-case basis situations are often considered. Oftentimes, the reciprocal certification process is as simple as filling out some paperwork. There's often information that needs to be collected by the state. Prove that the certification status in the original state is still valid, and that the certification hasn't been revoked, and or perhaps there aren't any outstanding violations, that sort of thing. And then, of course, all importantly, pay the fee to become certified. And so that's the good news, that many states really do have good programs for this. The not quite as good news, if that's a thing, is that sometimes although the initial reciprocal certification process can be easy, the recertification process still can sometimes remain cumbersome. So in many states, however, they have a streamlined recertification process as well, and that a company or an individual will just need to prove that they have met the recertification requirements in the original state, and then in the reciprocated state, there's kind of an automatic renewal of that license. Most of our technicians honestly recertify through continuing education. So in Virginia, Maryland, and DC, for example, there's different requirements for recertifying through continuing education. The Commonwealth of Virginia has a program by which you need to attend a program that includes multiple aspects, including category-specific information. core information, state laws, statutes, typically, and there's not a continuing education hour requirement. But typically those meetings, those will last 4 or 5, even 6 hours long in order to be approved for recertification. Maryland has its own requirements for recertification, as well as the District of Columbia. And so if it wasn't for kind of a streamlined situation that these states have, it could be pretty cumbersome to kind of figure out and then actually get those credits that would be required. And so when we see that they're streamlined, these processes are streamlined, and that if you're recertified in your original state, you are then, all you need to do is prove that you still have that valid license and you have completed the recertification process, then it's renewed in the next state. So that's the best case situation there. Now, the other not quite so good news is that we have honestly heard that in response to some of the new requirements put in place in the 2017 Certified Pesticide Applicator Rule, the EPA federal rule, that some states are now considering eliminating reciprocity and the agreement that they have with neighboring and adjoining states as a policy, and then dealing with those requests on a case-by-case basis. If that is the case, that could be problematic for some folks, and would just make that process a little bit more difficult and cumbersome for the applicator. So in our eyes, from a national perspective, really, honestly, national reciprocity for certification and recertification would be the best case scenario. I think that's probably unlikely. We argue in many cases, and we know that there are regional differences in how pest control is performed in different parts of the company. So national reciprocity, although would be the best case scenario for us, we understand that there are some challenges to that sort of a thing. But guaranteed reciprocity is something that we've requested through the comment period with the certification and training rule. NPMA requested that states guarantee reciprocity in adjoining states. That's not the law of the land now, but that is the best case scenario and what we would like to see. And then importantly, and I think something that we can work on with the states is that if we can, to the extent that it's possible, streamline that recertification and renewal process for reciprocal certifications, that would be ideal, because there's a lot of time that's spent trying to juggle the requirements, and I need 10 hours here and I need 4 hours here, but in this other state, but 2 of those hours need to be in this particular thing and another needs to be this. It can become difficult. In fact, in the days when NPMA, before we started to scan people in at Pest World, we would have the forms, the punch sheets, and you've probably seen these. And we would have technicians that would be carrying up and bringing, 10 punch sheets, because they operate in 10 different states and they needed to get their recertification in all of those states. I suspect some of those were reciprocal certifications that could be streamlined through a new process or agreements in which that recertification by continuing education is made a little bit easier. So I want to thank you for your time today, and what I'd like to do is turn it back over to Leo to talk a little bit about Indiana's perspective on this particular issue. So thanks, Leo.
Thank you, Jim. So, boy, as a state regulator, I really wish that I could tell everybody that how angry Jim's presentation made me, and by golly, he's totally off base. But that's simply not the case. Couldn't agree more that this should be an easy thing for everybody to do. But one of the things that FIFRA required 40 years ago and requires today is that if a state is going to enter into reciprocal agreements with other states that they have the authority to do so. Indiana has had the authority to do so since our state law was initially written, the Indiana Code. We've got the authority. We made that clear to the agency that we have the authority. And we wrote into our original state plan the exact same verbiage that was in our state plan for the last 40 years. And it was essentially, we will reciprocate with any state that has a federally approved state plan that's willing to reciprocate with us. EPA said, nope, that's not good enough. You need to put some more in there about what you're going to promise us that you're going to do. So historically, as I said, any state that reciprocated, that willing to reciprocate with us, that had a federally approved state plan, we were willing to play ball with. The caveat to that is, if an out-of-state applicator moves to a company in Indiana, they need Indiana exams. Reciprocity is not an option for those companies and applicators that are based in Indiana. So reciprocity is an option for out-of-state companies. And typically, as Jim mentioned, that those companies are immediately surrounding the state. The exception to that would be, say, the right-of-way industry, where they're coming from miles and miles away, or many states away, as well as the aerial application industry. Those folks come from all over the country. What tends to trip states up, and what the agency is resting their hats on, is this part of FIFRA that indicates a state has examined the standards of competency used by the state, tribe, or federal agency that originally certified the applicator, and determined for each category that will be accepted that they're comparable to their own standards. That was when states were first forced to really take a deep dive and look at that. That was really concerning. That could mean anything, if to determine whether or not you have comparable standards, or the exams of the same length and same rigor, or is the passing score the same, the same number of exam items. Ultimately, the agency said, you know what, as long as you're willing to attest to the fact that you've examined the individual categories and compared them, then we think that's going to be good enough. My contention is, because as Jim mentioned, we've heard, I've been in contact with some of my counterparts, and they've indicated, hey, we want to handle this on a case-by-case basis, or because what we've told the agency, US EPA, that we're going to do, we just don't want to reciprocate at all. My opinion is that there's not a whole lot to figure out. We're not special. As much as what we like to think we are, we're just not special. We've all determined what our applicators need to be examined over. We're not going to, nobody is going to do a deep dive on the data for their items to make sure that those standards of competency are comparable. That's just, it's mind-boggling to think anybody would want to do that. So really, the only thing to figure out, as far as I'm concerned, and as far as we're concerned as an agency, is do our certification categories match up? And we've been doing this for years. That every state's been doing this for years. Do you have a separate turf and ornamental category? Do you have you combined general pest and termites, or have you separated those out? And we all deal with those just fine. We don't need to muck up the process or to muddle the process. if one of our applicators from Indiana wants to go to a state where they've combined general pest and termites, they're going to have to prove that they've taken both the Indiana general pest and the termite exams, and that they're fully certified and licensed. It's just not that hard. And frankly, I'm disappointed that we're making it that hard. So moving forward, there are going to be some things that we need to do in order to stay consistent with our applicators and with what other states are doing. We're going to need to review our current agreements to with states, particularly those states that have indicated we may not be willing to reciprocate on a regular basis, and we need to compare our categories a little more vigorously, both state to state as well as federal categories. There are some federal agencies that require some folks to be certified, and some of those categories don't necessarily match up real well with the Indiana categories. For example, there's a in FIFRA there's a federal regulatory category. In Indiana, we don't have a regulatory category. So if somebody from USDA or APHIS wants to reciprocate, they're going to have to take our category exams, because frankly, they don't reciprocate with us as well. So with that, I hope if anybody happens to have any questions or comments, that they'll reach out. They'll give us a call here at the state chemist's office, or email us. And the same for Jim. That was news to me, Jim, that NPMA will be losing you, but look forward to continue talking to you and working with you in the future.
Well, thanks, Leo, and it's always a pleasure to work with you, and I really appreciate your insights today. Thanks so much.
Thank you. Take care.